Alrighty, let's begin. Now, on Monday we covered quite a bit of misrepresentation, right? And so, as I said, the goal is for you to, in your own time, digest the material from the cases and the legislation. What I've done is try to give you the roadmap as to how that'll apply. Just put the document camera on. Yeah, there we go. So the roadmap is sort of how we've gone there. You've got what is this? Quality projection, teach. There we go. Oh gosh, that's too bright. Anyway, we'll just do it with this. So I think, there we go. What we'll do today is we'll finish off just a little bit on remedies, which is not huge. And then we will do one scenario, because I think that will help you apply it, and then we'll spend the remainder of our time just sort of wrapping up the course. The parts of the course that I have taught you. I have posted on Canvas a set of revision slides, summary slides for weeks 1 to 2, 4 to 6, and week 8. So that's on Canvas now. You will also get a bunch of revision scenarios that are different from the tutorial questions and the scenarios that we have covered in class. And I'll put the notes up for that probably next week or the week after, just to give you enough time to sort of work through that, and then you can use the notes. And again, I would recommend that you use those scenarios to practice how you respond to exam questions. You can write them as plans. You can write them in full and do them in groups as well. I think that's going to be quite beneficial. Okay, so remember for misrep, there's sort of 6 things, right? We've talked about is there in fact a misrepresentation? Is it a representation, not an opinion, or puffery or anything like that? And then, was it made by one party to another? And that's really important, because that condenses the scope of misrepresentation as a cause of action, right? It says that just because somebody enters a contract under a mistaken apprehension does not mean they have a ground of misrepresentation. It must have been because the other party said something to them, communicated something to them that was factually incorrect. So that constrains misrepresentation. Mistake will cover more things, as you will see when you cover it with Marcus. And then you have to show that you were induced to enter the contract by that mistake. Okay? You have to show that it was a material cause to you entering the contract. You also have to show things like you didn't know that this was untrue. You knew about the misrepresentation. It was actively present in your mind. You took a reasonable interpretation of it, and it was reasonable for you to rely on it, and that the other party intended the representation to influence you to enter the contract. Okay, so it's not a straightforward question of someone said something and you believed it and it was untrue, therefore you have a cause of action in misrepresentation. You need to show all of those things: reasonableness, knowledge, materiality, and intention. So those are the four parts of inducement that you need to show. And then the last thing we covered was this idea of any liability being excluded by a contractual clause. And the big idea there, remember, is that there's sort of 2 ways that we can do that. Number 1 is to exclude or limit liability, right? To say that whether or not there is in fact a misrepresentation, the parties agree that the liability will either be $0, so there's no liability, or that it will be limited to a particular amount. Just like we would do for breach of contract, right? We would preempt the damages that would arise from a breach and give the parties certainty as to what they're entitled to if there is a breach, rather than leaving it to the court to determine the amounts. And that's perfectly fine. That's covered under Section 34. The court will not touch that, subject to other vitiating factors like mistake or unconscionable conduct or something like that. But generally, it's not going to touch that. or for some reason if it considers it illegal, but typically the court will protect that kind of clause. The other type of clause that we looked at was the entire agreement clause, right? And the entire agreement clause is not about what happens if there's a misrepresentation. It's about stopping the court from looking at whether there was a misrepresentation or not, or stopping the court from establishing the elements of misrepresentation, that there was a representation, that it was relied on, etc. Now, unlike an exclusion or limitation of liability clause, the court says that, Parliament says that that type of clause can be overridden if the court does not consider it fair and reasonable to be conclusive between the parties. That is, if the court doesn't think it's fair and reasonable for one party to be able to escape liability for a misrepresentation by relying on that clause. Okay, so that kind of clause can be overcome by the courts, not an exclusion or limitation of liability clause if there is in fact a misrepresentation. So one is about the outcome of misrepresentation, and one is about the process. And the outcome, the parties can contract, that's fine, that'll be protected. But if there's something about the substance of whether there is in fact a misrepresentation, the court can look at that and can make a determination and say, you know what, we can actually look at this. We can actually say there was in fact a misrepresentation and we should impose some sort of remedy. Cool, so that's kind of where we got up to. Any questions arising from that thus far on misrepresentation from Monday? Cool. If you have any questions, just let me know. And the last thing we want to cover is remedies. Now, with remedies, remember that for misrep, you've got two avenues, right? One, you've got Section 35, and one, you've got Section 37. So those are your two remedies, assuming that it's not a sale of goods contract, in which case it would only be Section 35. Section 37 we've already covered, right? The remedies there are as the court deems appropriate to award under Section 43. Okay, so that is what the court will award. Typically, the court will, as we saw in Newman's tours, the court will typically rely on, the common law principles to determine that. They won't depart from those easily, but they do retain the discretion to make a remedial order as they consider just, right? And so that you have to go by the wording of the statute in Section 43. So that's kind of by the by. You can go back now and look again at Section 43 to determine the remedial approach if you're cancelling a contract for a misrepresentation. And that can be quite broad. That can be, transferring property, transferring money, other types of orders as well. So just be aware that there's a broad remedial discretion there. If it's under Section 35, then it's just damages, as if the representation were a term of the contract that had been breached. And so this provides the calculation method for how you determine damages. Right? You say that you apply the same approach as if it were a breach of contract and that term was breached. In other words, that representation is not true. What would be the damages had it been true? Right? And that's essentially the approach. Okay? This material here is about how the courts quantify those damages, but essentially the big idea is, had it been true, what would they have gotten versus what they have now? And that's typically going to be the award of damages there that you're entitled to as of law. Remember, this is common law. It's not discretionary. If you succeed in a claim under 35, you are entitled to your remedies in damages. Right? This is discretionary. This is entitlement. So you can cite Dodds and Southern Earthquake Response Earthquake Services for that authority from the Supreme Court. That's essentially how you should calculate any damages if in the event of a misrepresentation claim under 35. Look, given the constrained time in an exam, if such a question were to arise, as with the cancellation remedies and other sort of remedies we've studied, the focus really is going to be on, establishing the cause of action, and then you can sort of make your best, not guess, but just make a good attempt at indicating what the remedies would be. And you wouldn't have to spend a lot of time calculating that, okay, under 35. Just say, it appears that they would have gained, I don't know, they would have gained $20,000, but instead they only gained $5,000. The difference is likely to be $15,000, and just leave it at that, right? That's perfectly fine. You're not expected to go beyond that for the purposes of Section 35 misrepresentation. Okay, so I'm just speaking for this area, right, that we're studying, but the focus really is on, that we've studied, is on about establishing the grounds of misrepresentation. This is just kind of what happens afterwards. I've just got a couple of points there about where the courts have said that other types of damages can be awarded for a misrepresentation. So not just the difference. The consequential loss or loss for anxiety and stress is possibly recoverable. So all you would have to note if you think that those damages may be available is just say, look, those damages may be available because, I don't know, the person has experienced anxiety or has lost a lot of money as a result, and that would be perfectly fine. You don't need to go into any more detail than that. And sometimes the amount awarded may be more than the difference between the representation being true and false. And really, all you would need to say is you can cite Marlborough, and it's actually Alti Marlock, the case, but you can just cite Marlborough, because in that case the court deviated from, made a different type of damages award to award them more for a misrepresentation because that was necessary to fix the problem, because they thought that a certain amount of water could be extracted from the land when they purchased it. It turns out it couldn't, and there was a significant amount of work that needed to be done to make that representation true, in effect. So the court said, we're not just going to do the difference, but the full cost of rectifying the water issue. So the application for you is that you really just need to say, if you think there's an alternative method of calculating damages that should be applied, just say that ordinarily it would be the difference. However, the court may decide that it's more appropriate to award more because that would better reflect the loss or something along those lines. That's perfectly fine. You can leave it at that. You wouldn't need to say more than that because we're not focusing as much on the remedies here. But the big idea is that it is the difference between what the plaintiff would have received had the representation been true and what they did receive on the basis of the representation being false. All right, well, I've given you a summary slide here, a couple of summary slides rather, which you can look at in your own time. And again, if you're struggling with the material, I recommend you use the summary slides and work backwards to try and give you a better understanding, because these are really the skeleton points that you need to know, or the questions that you would need to ask. So they're really there as a starting point for you. And again, just to reiterate, the order in which I presented the analysis is not prescribed by courts. Okay, so if you want to discuss things in a different order, that's perfectly fine, right? That's not prescribed. I mean, all of these are requirements, but it just means that you will have to determine how you want to best present the analysis. I think this probably makes sense, like you're sort of walking through the life cycle of the misrepresentation, but you're welcome to do it differently. The main thing is you do address all these elements. Okay, so is there a misrepresentation? Was it made by or to, by and to? Was there inducement? So remember the 4 things: reasonableness, reasonableness, knowledge, materiality, and intention. Show those 4 things. Any exclusions or any limitations or any entire agreement clauses. And then lastly, what would the remedies be, if any, under both 35 and 37? Typically, you're not going to be allowed to double dip, right? So as I've indicated before, if it's just about cancellation, but 1 award may suffice under 43. That's perfectly fine. But if but note anyway that there's an alternative in 35 where you can just get damages if that's what your client wants to do or the plaintiff wants to do. Cool. Questions? Anything unclear before we move to the scenario? All right, maybe there will be more questions when we go to the scenario. So there's a few of them actually. I think we'll do this one. Okay. So this scenario is about Odessa, and I'll just put on both screens, yeah. So Odessa is a talented netball player. She's 22 years old. She's previously represented New Zealand at the Commonwealth Games. She rose through the ranks at the Wellington Wonders before the Auckland Tigers sought to lure her north during contract negotiations, which is 1 week before the start of the elite netball season. The Tigers' legal counsel, Sanjeev, asks her, so no injury risks, right? You've had a pretty good run thus far. And Odessa says, nothing to report here. She then agrees a deal with a salary of $4.5 million a year after tax, with a $100,000 signing-on bonus, and is unveiled as the Tigers' latest marquee signing, with promotional material that states she brings pace, power, and athleticism to a maturity. Her contract had no stipulations about her health status. The day before the negotiations, Odessa had been in the backyard playing with her niece when she felt a twinge in her hamstring. Her physiotherapist friend Mark is in town, and he had a quick look. His initial diagnosis was that there was a grade 1 hamstring tear, which would heal within 6 weeks. He then stressed that this was an informal diagnosis or informal assessment, and she needed to go for scans to confirm the damage. The next day, she thanks Mark. The next day, she wakes up, she feels fine, and she goes to the negotiations and then signs her contract. During the 5th minute of the season opener, Odessa tears the same hamstring and snaps her ACL in the same movement. The doctors note the injury was aggravated by the prior injury she suffered, and doubt that she will ever recover more than 50% of her athleticism, even if she makes it through the proposed 18-month rehab program, which is quite significant. Mark gets a job with the Tigers subsequently, and by chance, on a drunken night out, he tells his colleague about his informal diagnosis of Odessa. The colleague tells Sanjeev, the legal counsel, and so your job is to advise Sanjeev, who's acting on behalf of the club. So you're advising the club. Now, let's break out into our groups, 2, 3, 4 around you. Take about 5 to 7 minutes. There's quite a bit of material here. Consider how the stuff we focused on about misrepresentation would inform your analysis, and focus on all the steps and see what you come up with. So 5 to 7 minutes, and then we will see what your thoughts are. All right. So this is a quite interesting scenario. There's a lot that could be said. So we're not going to get to all of it. But let's hear what you guys came up with. It sounded like there were a lot of interesting discussions. So how would you approach this problem? Everyone want to start us off? Yeah.
What was the representation that the sports team relied on?
So what was the representation? So you've figured that out. What do we think? Yeah.
We were saying that it was her saying that like she was fine and she had no injury risks.
Yep. So that would be the representation, right? So again, this is the issue. Identifying the representation you are trying to ground your claim in is going to be one of the main things that you do with a misrepresentation analysis. So the idea is that she's fine, right? It's helpful to write out the statement. I'm not going to do it here, but you can write out the statement. If it's not the actual statement, then what is the fact or representation that's not true that you're claiming? Yes?
For the representation, because it occurred before she even knew she was injured, so wouldn't you have to do the failure to disclose changes?
Yes. So, but potentially. So this is where we have the timeline, right? This is really important. So if we do the timeline, you've got she's playing in the backyard, right? Negotiations here, representation, and execution of the contract. Right? So this all takes place over a day. Right? So the representation comes after the purported event. Like we don't, we're just assuming that that's kind of that's kind of what happened there. Right? So a good illustration of why we timeline it out. So when you go into the exam, bring in pen and paper and rulers and whatever else you need so that you can graph this out. But good pick up on the timing. What else? How would we approach this one? Yeah.
I think we were sort of thinking that the actual statement, the representation that she's made, there's nothing to report here. It's sort of more of an opinion because she's sort of expressing that she feels fine. And so it's more of a situation where you've got the opinion and the underlying fact is, I'm fine for the season, we're starting in a week, I'll be able to play for the whole season, I'm in good condition. Even though she's not explicitly said that, that's the real representation that's happening here.
Yeah, so really good, insightful idea. This idea that she's giving her opinion, but in doing so, she's communicating a statement of fact about her physical capacity. What else do people think about that? Opinion, fact? Like, how do we resolve that?
I was kind of leaning more that it was more a half-truth because, no injury risk, right? And she has an unofficial diagnosis, which is she had an official diagnosis, and clearly stated nothing, and that's obviously misrepresentation. But there was no need to disclose that. And I feel like risk that an unofficial diagnosis would constitute that.
Yeah, absolutely, right? So, is this an omission that would ground a claim of misrepresentation, right? Is her failure to disclose that something occurred yesterday, right? But she doesn't sort of fully know, right? Is that enough? What else? What about the nature of the representation or what she says? Could we say, or did you guys come up with? And there's many angles that could be pursued with this opinion, fact, whatever. Yeah.
I think when the sports team is asking the question of no injury risk, I think she could have interpreted that as severe injury risk, an injury which would take her out of more than half the season, perhaps. something that would stop her from completely playing the game. Because sports players often play with injuries, right? Their muscles are sore, their feet are, something's like, they're not completely 100% bodily fine.
Yeah.
And so I think the true interpretation of the question and the representation she gave was that she's mostly able-bodied, that she would be able to play for most of the season.
Yeah, so really good point, because we remember that the inducement requirement is about what is a reasonable interpretation of the representation, right? So if we pull that back, what is she saying? She's responding to a question. The question is in a context. It's in a context of a professional negotiation between a professional sports club and her, a professional player, right? So the argument would be that she is giving an answer that is correct in the context about the fact that there are no serious injury risks that you need to worry about beyond the average niggle and wear and tear. Like, that's sort of the argument. And you know, certainly athletes do play with injuries. You wouldn't need to know that as in for the purposes of an exam. Like, so that kind of extraneous knowledge, like, you know, potentially could be helpful, but it's not going to come into, if you don't know that, you're not going to score as highly. Okay, so just be assured of that. But absolutely, athletes do play with injuries, and that's a valid point to make. What do we think about whether this is a representation or a term? Because that will determine sort of the avenue by which you advise Sanjeev or the club to go down. Yes.
I don't think she's necessarily representing it to be a term, and one of the part from the slide was that, you know, it's what was representing how people communicate. But I think you could, if you're viewing it from the Titans' perspective, I think it could be more of a term from their perspective, because they've advertised as a marquee signing. And I quickly Googled what that means.
Yeah.
But it's about having, you know, someone who's famous who's going to bring people into the club. And there's no point having your most famous player sitting on the bench for 5-6 weeks.
Yes.
Possibly long term. And so if they're, you know, hiring Odessa because she's, you know, well known, because she's likely to bring people in, then you'd want to have her in a position where she's actually going to play to get people into the club. And so having her in good health is an important part, which could be seen from the
Absolutely, right? So, the argument is that from the perspective of the club, right, they regard this as a warranty or a term, just like in Oscar Chess, right? The argument was that the motor vehicle company, they wouldn't have bought this car had they not been assured that it's going to be a car of this year, right? That's sort of the argument. So it's an interesting approach. So that would require you to look at how the courts have applied Couchman and Oscar Hill, right, into determining what is a representation or a term. What other arguments could we raise in response to that? Because that's quite foundational, representation or term.
Could you just say it's kind of a risk of signing a professional sports athlete that they may just get injured? Like, sports athletes get injured all the time and they would not be considered a breach of contract.
Yeah, absolutely. You could validly say that. You could say, well, this is not there's no warranty that the player won't get injured at all, right? So that would be the claim. Absolutely, taking into account that risk is really important. What are the arguments? And when you see the notes, you'll see that there's no clear answer, right, for this. So there are good arguments on either side. But what are some arguments that you could run in Odessa's favor, like to preempt the arguments from Odessa that this wasn't part of the contract, this was a representation only? Absolutely, yeah. So remember what I think it was Lord Denning in Couchman said, right? Like, if an oral representation is subsequently entered into in writing, that's more of an indicator they intended to be a condition or a term of the contract, right? And if you, and this is where you can pull elements from other cases as well. Feel free to do that. That shows complexity. So remember in PAE and about the Section 50 case, remember what the court said. The court said that PAE could not resile from the entire agreement clause because they had every opportunity they needed to include in the contract any warranty or guarantee that they needed. If they wanted to be able to sue in the event that this thing was not true, this statement by the directors was not true, they had the opportunity to make it into the contract. They didn't, and that decision means that they shouldn't be able to, subsequently sue for that. Now, I should say as a sidebar, when you do incorporation of terms at the end of the semester, that will be material as well. So you'll need to bear that in mind, how terms are incorporated into a contract. That will influence your assessment of whether or not this is a term or this is a representation. But for our purposes, Couchman, Hill, and Oscar Chess are sort of the bare bones of that for the purposes of misrepresentation. All right, so you can see how this is quite tricky, right? Because we haven't even gotten to the other steps. So here, by and on behalf are probably not as contentious, right? So we can dispose of them in a sentence. So Odessa says this to Sanjeev, who's acting on behalf of the club. That's negotiations. That's perfectly fine. Dispose of that in a sentence. Don't spend more time than necessary on that. What about inducement? What would you say about the inducement element of misrepresentation? No, you would because it's what a reasonable person would do, having all the knowledge of the representee, right? And so, absolutely, you can certainly make that very valid argument. And you're right, most clubs would do like a medical of some sort, right? So the issue is, was it reasonable of the Tigers to rely on her statement to enter the contract? What else about inducement would we say? What are the four things? Knowledge, reasonableness, materiality, intention. What do we... And you need to show all of them. So what would we say about them? Yep. So that one's reasonably clear. Like that's going to be, like they knew about it, right? They were aware of it. What about the other ones? So we've got reasonableness, intention, and materiality. Sorry, did you have a hand up down the front here? Did you have a hand up?
Yeah.
Yeah.
You could say that she didn't necessarily intend to mislead them at all.
Yep.
She was just saying what she believed or how she felt on the morning.
Yep. So the argument was she didn't intend to mislead them. She just was stating how she felt in the morning. Other thoughts?
When it comes to interpretation of what the representation actually was, the question that Sanjeev asked was very vague in terms of no injury risks. It's not saying, have you ever had an injury? When's the last time you had an injury? It's asking about what's the risk. That risk level is subjective. So it might not be reasonable to rely on
Yep.
Whereas, what we talked about earlier, the best way to do this is asking, do you have it, when was the last time you had an injury, or subjecting to a medical examination,
Yep.
so you actually have that knowledge for yourself.
Yeah, so it's a really good point. So the question itself is material to the issue of whether or not this is a reasonable reliance as to whether or not the Tigers can reasonably rely on her statement to enter the contract. Because, if the question is clearer, then the representation is clearer, right? And there's sort of less ambiguity, and you can more clearly situate a claim for, is this an untrue fact or not? So it's a good point. Other thoughts?
Argue to counter that, you've got to imagine that in materiality, if she had answered the affirmative that she did have a risk, you've got to imagine that on the Tigers' part there would have been a follow-up, and she must have known that there would be a follow-up if she said, yeah, I do have some risks. They're not just going to be like, okay, still give you the contract.
Are you saying that the representation is material to them entering the contract? Yeah. So it's material to them entering the contract because it's a significant cause, right? You're right. If it had been anything else, that actually I twisted my ankle the other day or something like that, right? Then that's gonna be important to them, right? So it is important to them that she doesn't have an injury. So two things can be true. Materiality is about, in fact, did they rely on it? Reasonableness is about, should they have relied on it? And those two things can absolutely be true, but it needs to be, all of them need to be shown. On intention, just remember that the intention is not to mislead, but the intention is to induce to enter the contract. Okay? So this is because neither 35 nor 7 will penalize innocent will only penalize fraudulent misrepresentations. They cover innocent misrepresentations as well. So the intention is not to defraud or to mislead or to lie, but the intention is, I'm saying this thing so that you will enter the contract, that it will influence you to enter into the contract. Okay? Now, we don't... I'll leave you to look at the notes for this because I think it's going to be quite interesting. You'll see when you see the notes that there are good arguments either side. So the conclusion is less important. What matters is how you got there. And that really is sort of one of the takeaways that I want you to take from our time together. It's that your reasoning matters, particularly if you're going to go into litigation. You're going to be given a client's file, and you're going to have to argue that position to the best of your ability, right? Especially if you end up in criminal defense, right? You're going to have to argue some pretty unsavory cases, and you're going to have to defend and argue that that reasonable doubt is there and all sorts of things. But you have to do that. That's your job as a lawyer. That's your duty. And so the quality of your reasoning is what matters more so than the conclusion. The conclusion needs to follow from your reasoning. That's all. So that's that scenario. There are a few more which I'll put on Canvas, and so you'll have that. You'll have the notes, and there'll be other revision scenarios as well. Now, just as we finish up, I'll put this up here. I won't go through this. This is actually self-explanatory, right? So this is kind of a summary of all the stuff we've done. Right? So we started with cancellation. We talked about the 4 grounds to cancel a contract, right? Breach, repudiation, misrepresentation, anticipated breach. Just remember that essentiality and substantiality, one of those needs to be made out. If you are doing a misrepresentation analysis, don't forget that if you're talking about cancellation. After representation term, by to inducement, you still need to show the representation was essential, or it not being true had such a substantial effect on the bargain, right? That will occasion you to cancel the contract, not just the standard misrepresentation, okay? Remember that you need to be ready, willing, and able to perform your obligations to cancel the contract. That's really important, right? And then if you affirm it, you won't be able to cancel the contract. And then we talked about really the remedies, which is kind of this thread that's going to go through, right? Because Section 43 is a broad remedial discretion. When we moved on to illegal contracts, we saw that Section 76 is a broad remedial discretion as well. And we saw with restraints of trade, there's a broad remedial discretion under Section 83, right? And so the 83, 84, I should say. And so one of the themes that we've looked at is the court is given a broad discretion to determine what the remedy is that it considers appropriate. There are guardrails, which we went through, and you'll need to be aware of and apply them if they arise in an exam. But the big idea of those remedial approaches is they're very discretionary, and ultimately it's just about you presenting a potential remedy that reflects the wording of the statute, fair and reasonable, just and reasonable, whatever the wording is for that particular cause of action. Okay, so that's for illegal contracts, restraint of trade, and cancellation. For undue influence, unconscionable conduct, and duress, remember the roadmaps that I gave you. Okay, how do you determine whether each of those is made out? If a circumstance arises, it may well be that different causes of action are enlivened. So feel free to apply different causes of action as appropriate. Reason in the alternative. Pick the strongest one, but then just mention the alternatives and why they would also ground a claim. And correspondingly, why the others would not be grounded. For example, if it's unconscionable conduct but not duress. And then, with misrepresentation, particularly misrepresentation, as with all these modules, they're very fact dependent, right? A lot of this is on deep engagement with the facts. So when you go back and do your revision, I would focus on answering the question that you are asked. Okay? Remember the question that you're asked, deeply engage with the facts, read deeply. Don't rush to answer them, because then you may go off track. Okay, and this is sort of general exam tips. There's time management tips as well there, and I want to just highlight the importance of clear notes. Okay, when you go into the exam, it is open book, right? But there's lockdown browsers, so you have to print out stuff or bring in printed materials. You want to have easily accessible, concise notes, because you will be spending your time typing. Okay, you will have quite limited time. So you need to make sure that your notes are clearly set out to say exactly what they need to say and no more, right? You don't want to be flicking through hundreds and hundreds of pages to find the material that you need. Okay, I'd recommend doing practice questions and practice scenarios. Do them under exam conditions, just to familiarize yourself with that. And sleep and eat well as well. I think that's going to be really important. Anything else? Oh yeah, so just as our time together comes to an end, I just wanted to say, do your best and back yourself as a bit of an encouragement. I think that's often it can be, you might feel at law school that you might be thinking, oh, I'm really stressing, or I'm not achieving as well as I want to. You can only do what you can do, right? So ask yourself, what is the best I can do, and do that, okay? And if you've attended class, if you've watched the recordings, you've done the notes, done the reading, then you're in probably the best position you're going to be in, right? So do that, and then don't overly stress. Do what you can, and then and back yourself. You are all intelligent, capable students. I've always said that, and I say that in public as well. So I fully expect to see really awesome exams. And if you do have anything about careers that you want to chat, I'm very happy to do so. Email me after exam results are released, and we'll make a time. I do have office hours today at 3. My Friday one, I have a doctor's appointment, so I'm not going to make that, but Wednesdays and Fridays at 3 o'clock for the rest of the semester. Thank you all for being a great class, and I look forward to seeing your exams. Thanks, everyone. No worries. Yes, sure. Yes.
You say like when there's provisions that limited the outcomes of like the misrepresentation.
Yep.
Does that mean the court cannot look at it at all, or and just like purely about the provision in the contract?
No. So, sorry.
It means that the parties are not concerned with whether the court looks at the contract and looks at the circumstances to establish misrepresentation. What they're concerned with is the outcome. Yeah, so section 50 would stop them from. So section 50 would allow them to look at a contract or representation despite the rest of the contract.